Good morning. My name is Gianni de Stefano, and it is a pleasure to participate to the OECD Roundtable on Sustainability and Competition Policy. In this short video, I would like to address three questions: whether sustainability and competition law clash between them, whether they actually help each other, and finally, what is the future for competition policy and sustainability. Now, starting with the first question, whether sustainability and competition law are the clash of two words. So I guess that we need to understand first what sustainability is today. And therefore, I think that we should recognize that while being very welcome from businesses, for example, it does represent a toll on the industry, a cost for the industry. A second point that is important is the fact that support is being offered, for example, in Europe by both the Union and the states for green projects of different businesses. And then there is also the point to be made that collaboration and private investment, it is part of the equation. It is being considered as part of the solution for sustainability. And I recommend the OECD indicators on sustainability. You can see the address on the slide because they offer a lot of granular data about the topic. Now, what does sustainability need? Sustainability, first of all, can be considered a market failure because, for example, the product may not include the cost that is needed to provide indeed a sustainable, a green, a clean product on the market. And therefore the price is not the true price. Secondly, there is a first mover disadvantage. So the fact that, for example, when a company is going to produce a clean product on the market, it will have an added cost and could be a price cut from other peers, rivals. And then there is the tragedy of the commons, a classic problem. So the fact that, for example, the company that is bringing to the market a non-clean product is only sustaining a small part of the cost in terms of pollution that the whole society is sustaining. So somehow there is a mismatch between the society and the individual incentives. So adding all these elements in the equation, it results that collaboration between firms may be the solution. And so that is the need of sustainability. How is competition policy, competition law, antitrust law addressing or not addressing that? Well, some commentators have been commenting on the fact that competition policy would focus solely on consumer welfare. And so, for example, not on consumer benefits. Another point that is being made is that competition law would focus only on short-term efficiencies and not, for example, on the long-term targets, for example, 2030 or 2050 as per Paris or agreement or the EU Green Deal. And finally, the final comment that is being made is that competition law would focus only on price-related effects. And so, for example, not on sustainability objectives such as climate change mitigation. Well, my position is that competition policy is actually also addressing its enforcement towards a direction that includes sustainability. So let us take, for example, the recent European Commission call for contributions on competition policy from really very recent, from October of 2020, where indeed it includes this concept that competition law is about the optimum allocation of resources, and indeed, for example, for energy efficient technologies. Another important point is that competition law does not focus solely on price, but also on concepts that are quality, variety, innovation. These are things that come from even previous policy statements in Europe and around the world. And then finally, the fact that competition authorities for example, the European Commission, have been open for guidance. They've been stating clearly that if a business has a question, they could go to their door and knock, and they will receive an answer. Now, the second question is, isn't it that there is more competition law helping sustainability? And so I have some examples for that. So firstly, the fact that competition cases are addressing delayed environment benefits. So you can see a couple of cases on the slide. For example, the fact that there is, let us read the quote here. The Commission investigation revealed that companies had engaged in a cartel relating to the timing for the introduction of emission technologies to comply with increasingly strict European emission standards, where, again, the Commission opened up, the European Commission opened up cases against that. So somehow helping the sustainability cause. Now, there is also the question of environmental standards. So that is something that would not represent a violation of competition law. And so that is a possibility. Now, there have been comments that, for example, certain guidance of authorities are not clear-cut on that. And indeed, for example, the authority has been hearing about these comments, and it is very likely that the European Commission horizontal cooperation guidelines are going to introduce a new chapter specifically dedicated to sustainability agreements. So that is good news. And then another thing where I see really convergence between sustainability and competition law is their fight against the greenwashing. And so there is even a set of legislation, for example, in Europe, the European Union taxonomy regulation, that focusing on that is offering a classification indeed to make sure that private investment are not generally labeled as sustainable, but indeed they represent tackling an actual tackling of the climate change concerns. And also some authorities are focusing on more generally sustainability claims to make sure that they are not misleading. At the same time, the competition authorities are also making sure that environment sustainability is not used as a label to hide hardcore violations of competition law. And so, for example, you can read on the slide an example of a case where indeed the environmental initiative was then covering other agreements were related to price, etc. Now, one point that I would like to make is that sometimes it is not only about greenwashing, it is about blurry lines in the sense that it is not transparent. What is the standard? What is the good or bad model? And so that is why, again, cooperation between companies, discussion to make clear that the standards is right is something that should be welcome. And then the final point that I would like to make is about the future. So what do we have ahead of us? Now, the EU Green Deal, building on the United Nations Paris Agreement, it is something real. So I think that the EU Green Deal is for the competition community today what the European Union market integration was some years ago. So something that you cannot discard, you cannot not take into account in your advice and from the agency side in the enforcement initiatives. And so competition policy will need to be consistent with the EU Green Deal. That is something that the EU Green Deal legislation is clearly indicating, and it is also something that is constitutional. I'm referring, for example, to the article on the principle of consistency in the EU Treaty. And what is then the sustainable future of competition policy? A competition policy that takes into account sustainability. Will it be recognized that finally green collaboration between competitors is not only to be allowed, but even to be encouraged? Of course, avoiding red flags. Regarding state aids, we've seen, for example, some examples of member states that impose beneficiary some green requirements. Will that be generalized? Will the member states agree on that? Will there be political support for that? And then for merger control, will the fact that two companies are sustainable be helpful in the assessment rather than a non-sustainable company being part of the deal? And so I'm looking forward to the 1st of December Sustainability and Competition Policy Roundtable at the OECD. I think that the stakeholders that we need for this journey are daring governments, flexible authorities, cooperating businesses, and brave lawyers.